Okay, I am today reproducing my presentation from last week, September 11th. I think it's going to be more concise and helpful to people. And as you can see by the title, I'm showing you how the IRS sets the standard for deciding how you can avoid or manage financial risk. If you use the IRS standard, it's going to help you with everything. I'm going to show you how to apply this when you're looking at a method, when someone's trying to sell you a trust or an offshore company or any sort of asset protection strategy or plan. You should understand that there's a standard that you should consider. And also, what's usually missing from that presentation is the identification of the risk that the structure or whatever is intended to avoid or manage. No one talks about the risk. They just talk about the name of the thing that they're selling you. So I want to give you a way that you can measure by a standard established by the IRS. You can measure this against any other asset protection strategy. I have some, other people have some. You can then decide. And before we get into that, I would like to say a few words about Charlie Kirk, if I could possibly do that. Uh, Charlie Kirk's life work. And by the way, I had written this out, so I don't want to miss anything here, but it's important that we recognize this, I think. Charlie Kirk's life's work was a call to action. It was a reminder that freedom is fragile and must be defended by every generation. Through Turning Point USA, his media presence, and his countless campus debates, he inspired young people to stand boldly for individual liberty, free markets, and constitutional rights. He reminded us that free speech is the foundation of a healthy society, that faith and family are the cornerstones of cultural strength, and that civic engagement is not optional but essential. His most important message was simple but profound. America's promise of freedom will endure only if each of us has the courage to defend it. Okay, and I think he was interviewed one time, and someone asked him, what is the one thing you'd want to be remembered for? Of course, he didn't think he was going to be killed at age 31, but he said if when he dies, he wanted to be remembered, or his life's work, whatever he did, for what he wanted to be remembered was that he wanted people to remember his courage for his faith. So I just want to convey that. I thought it was important. I hope it is to each of you. And with that, I want to proceed to what we're talking about. So I'm going to show you where I get my standards from. So you'll see in my content when I talk about different solutions for financial risk, okay, and other matters that are related to that. I make videos and I explain strategies. I create documents. I provide those to my members, and you'll find those at aceofcoins.club. Okay, the video membership. We have some new modules coming up. You might want to check it out. And then aceofcoins.com is a way to schedule a consultation with me. And I do consultation programs. So that means I work with you for a period of time. Typically, it's a year in doing something, implementing something I set up for you, or helping you do something that you wanted to do. So I have a consulting program at aceofcoins.com, and there's also a place where you can register or schedule a time to talk with me. My calendar is at aceofcoins.com is what I'm saying. So check that out when you get a chance. So let me just do a share screen, and I'm going to show you where I get my understanding about when I look at things. There's other factors too. We'll get into that, but let me just do a share screen, and I'm going to show you. Here we go. So I start with this. I start with the most effective debt collector we have in the United States. Okay, that's going to be the IRS. Why is it like that? Well, the IRS has been given the ability, okay, or the authority or the means to take property and talk about it later. So under Title 26 of the United States Code, okay, in Section 6331, you've got paragraphs A and B I want to focus on. This allows the IRS to just take property from when it makes an administrative determination that someone owes and doesn't pay. The IRS can then look for the property of that person and take it. So it has a lot of power there, but it's revealing, because if you understand where the limitation is, I mean, this is a pretty powerful statute. And I can tell you right now that debt collectors and creditors and people that sue you and get judgment liens against you, for example, don't have this power even if they have a judgment lien and get permission from the court to execute against property and property rights, it's expensive to go through that process. And the IRS has a much more efficient way whereby it can take the property first and or if you want to challenge it, you can pay and then challenge it in court, or you can go to tax court, which I don't recommend. There's a couple of problems with that. But what I'm saying is an administrative process, okay, that you're subject to. Okay, this has to do with the sovereignty of the United States. Because the United States is a nation, it can decide how it interacts with the taxpayer. So we kind of have to go along with it. And the same thing, we're under the rules of civil procedure when it comes to debt collections. So here's the standard by which I look at everything. So the first one, beside the statute, is can my client avoid cost of litigation with what I set up for him? And most of the time it's possible. Most of the time I can do that by the way I create the relationship or the contract or the membership agreement with my client and his customer, for example, or with counterparties that he's dealing with. Now, I use this standard here, avoiding cost of litigation, and can I defeat this legally? 6331, okay, paragraphs A and B. So we're talking about any person liable to pay a tax, okay? We don't need to read the whole thing. You can if you want. Gives the IRS the authority to do this. The secretary may levy upon property or rights to property. This is so important. If you have the right to sell it or spend it, and it's exclusive, it's not shared with someone else who doesn't have the same liability to the IRS as you do, then it can be taken by the IRS without suing you. Now, sometimes the IRS has this ability and it will sue you first. I don't know why. Maybe it's just, I don't know, maybe there's some rule that requires it, but there are situations where the IRS could just sell your house. I think typically the policy is that instead of just selling your house, unless there's a jeopardy assessment, I believe the IRS will use the federal courts to get a judgment first and then foreclose upon its rights over the house. I think that's how it works. So, but anyways, I believe that's optional. So if I look at everything like this, here's my one solution to having risk. Let me describe a general risk that people have. Let's say you set up a company to run a business or manage cash flow of some kind. Maybe you have some rental properties. Maybe you have a website. Maybe you're just selling some gold, one-time transaction, okay? So you have a limited liability company. Let's say you're using this limited liability company. Well, your accountant can set it up, and your accountant's typically going to set it up for the sole purpose of tax reporting. There's going to be no asset protection considerations at all. So just be careful when you have like a tax person to set it up, okay? The way I set it up is for managing financial risk. Taxes being just one little teeny tiny amount of financial risk. That's how I look at it. Cost of litigation being the primary concern, the taxes being secondary concern. That's how I look at it. So if I have a limited liability company where I'm getting benefits is this. I'm paying a fee to the state to obtain indemnification. It's an insurance arrangement. Understand that the state is going to protect your interests in the company as long as you do what you say you're doing and you're not breaking the law. So here's how this works. If you're the only owner of the LLC, then you have no protection. Now, titling property in the LLC is pretty good, but if it's tested, there's no need to pierce the corporate veil, so to speak, because if you're the sole owner of the LLC, there is no corporate veil. Okay, it's just disregarded or something. Don't get that confused with the tax term disregarded. It's just it's almost like a sole proprietorship. Okay, but lots of times you'll be effective if you're the sole owner of an LLC. Now, if I'm setting up something for a client where he's got active collections going on, I will never let him just be the sole owner. Okay, I need another person. Maybe it's his brother who's just a nominee. Maybe it's his mom. It cannot be his spouse. So that is what we are looking at here. So if the IRS, the most effective organization to be collecting property for whatever purpose, taxes, whatever, can levy upon the property or the rights to the property, that's the most severe, because if I have the right to spend money, the exclusive right to spend money, and I have the exclusive right to sell property, the property being real estate or stock or something that's not exempt, right? Like a 401k is going to be exempt, right? A pension fund is going to be exempt unless you're not filing returns. That's a different matter, more or less, or if there's fraud involved. But for the most part, pension funds are exempt, right? So the LLC, through the state's indemnification, when you pay the filing fee, you have perpetual indemnification, by the way, even if you don't keep your charter in good standing, from what I understand. So uh, the LLC allows the state to recognize the independence of the LLC outside of the owner's estate. So to get what's called charging order protection, which means that if there's an order to take or seize property from one of the members of the LLC, that can happen. The order can be fulfilled. The court order can be fulfilled. One, if there's only one owner to the LLC and the one owner is the debtor, okay, he's the judgment debtor, judgment lien, or he's the subject of an IRS levy, okay, then the IRS could go around the LLC. Usually they don't, by the way, but it could go around the LLC. And the other way is if the member of the LLC, under any circumstance, if he's receiving compensation from the LLC, he takes the money out and puts it in his personal bank account. That transaction can be levied upon from the LLC when it leaves the LLC. It's payable to the member, or it can be levied upon if the member puts it in his personal bank account. All right. That doesn't matter what the ownership is. The benefit here is that if your ownership is more than one person, so you're having a shared right of the property, when the property rights are shared between an innocent party and one who's the debtor, for example, then you've locked up the property such that it cannot be levied upon by anybody, not even the Department of Education, okay? Not even for student loan, IRS, judgment lien creditors, okay? This is known as charging order protection. And this is why I like LLCs so much, because it's so easy to get the protection because the state gives it to you as a matter of law. It's a statute. If it's not a statute, if you want to write it into a trust agreement or a partnership, you can certainly do that. It's just that you have to defend it then, and it's subject to litigation. That means if someone's going to test whether or not you have the right to the property or the property itself, he can test it with the subpoena, getting a subpoena for the partnership agreement or the trust contract, the corpus of the trust, right? He can find out what the rights and obligations are of the trustee, the beneficiaries, or the partners, and maybe possibly break through that arrangement. Whereas an LLC, your protection comes by the fact that the articles that are public record show more than one owner. Okay, now, if both owners have the exact same liability, like for example, let's say the LLC gets into a lease agreement, a commercial lease agreement for a retail space, and the landlord makes both owners of the company guarantee the debt, right? So they have the same identical debt, and then they don't pay the lease agreement, then they're liable. The owners are liable. So there's no protection at all. What's happened is if you're the guarantor on a deal where your LLC is involved, if you're the guarantor, you're effectively you're stepping outside of your corporate protections, your LLC protections, and you're taking on the personal liability. If both partners do this, if both members do this, then there is no protection at all with regard to that particular lease agreement. You're still protected against other creditors. You see how this works? So I want to address this thing. So part of this has to do with, I mean, I hear for 33 years, I've been hearing all these different fancy names, structures, and strategies, and unincorporated associations, and foreign offshore trust organizations. It's just craziness. And not once do people talk about the individual risk they're looking to avoid or manage. They're just wanting to sell you something that sounds pretty cool. And most of it focuses on avoiding KYC or avoiding the disclosure of your name and identifying information. And just so you know, that is not the risk. Okay. That doesn't cause financial risk. Okay. Disclosing your name does not cause financial risk. Avoiding financial risk, it involves changing property rights in such a way that you defeat 6331B. That's your standard. What is the risk? And can I divest myself of the exclusive right of the property as far as they're concerned, and the exclusive right to sell property or spend money as far as anyone else is concerned? If I can do that, it passes the test. That's all that I care about, right? That's how I measure whether or not I'm going to be effective for the client. That's how you want to look at everything. So if someone comes to you and says, "Hey, I got this great trust thing," and it gives us some fancy name, And so my first question is, okay, sounds interesting. Is it revocable? Is the property conveyed in the trust revocably? Or is it irrevocable? So I cannot take it out as trustee. All right, so that's the determining factor, because if it's revocable, you don't pass the test under 6331B if it's revocable. If it's irrevocable, you probably do pass the test. It is subject to evaluation, though, by a judge, possibly, okay, or by an administrative review. So just keep this in mind. That's how I look at it. Now, there's another risk factor here. Again, when you're looking at, let's say, these offshore structures, offshore entities, right? IBCs, LLCs, limited partnerships, foreign trust organizations, okay? These are still subject to, switching over to Rule 69 of the Federal Rules of Civil Procedure, for post-judgment discovery. Now, I use federal rules here because the state rules are written almost identical language, okay? So if you want to look in your state rules, you'll see the same thing. The reason why I use federal rules is because if a creditor, even the IRS, wants to reach out to your foreign company, if there's if they suspect that you're somehow connected to a foreign organization, even if you're not named on it, okay, the federal court would be the proper jurisdiction to reach out into that foreign jurisdiction, and they would use Rule 69. Okay, now I believe you could probably use the state rules for this purpose, but let me just show you what we're looking at here. So in aid of judgment or execution, collect the money, go levy it, right? Say someone has a judgment against you. Let's see. He may obtain discovery from any person, including the judgment debtor. So any person means your bank, right? So if the people behind the collection process, the lawyers, think that maybe you're moving property or money offshore, they can use this rule or your state rule to compel you to talk about it, to give up information, even if your name doesn't appear on any of the documents, you think you escaped them, right? But they can see that you're somehow connected to it because of the way money's moving. They can reverse engineer your relationship. Even if you don't have a contract, the court can reverse engineer your relationship to the entity or the offshore bank account and determine based on the way the money's moving, your relationship, okay? And so this rule allows the discovery, but understand that in the rules of civil procedure in your state and federal, the judge can order you to answer these questions and or be held in contempt of court. And the judge has the authority. I don't know any way around it, unless you have successfully divested yourself of that and you can honestly say, I don't have control or custody of, right? You can do that easily with an LLC. It's very difficult to do it with these, IBCs, foreign trusts, and all these things. So that's the essence of what I was talking about a few days ago. So I had to redo this because I believe I didn't make the recording. So in any case, that I hope helps you look at all these different methods that you may come across. Unfortunately, you have a lot of people that don't understand the tax system and they're tax protesters, so to speak, and they come up with these wild ideas about sending protest letters to the IRS, which are meaningless. All right. So what really matters is whether or not you've created a duty to reconcile a report that the IRS received. That means like a 1099, right? So if the person getting the 1099 normally files tax returns, there's going to be a duty to reconcile. If the person getting the 1099 hasn't ever filed tax returns, the IRS doesn't care, because the IRS doesn't see that as settled funds, like the destination has been reached. Okay, they're still waiting for the money to arrive somewhere in the hands of a taxpayer, so to speak. Okay, so as long as you can arrange it to where it's unsettled funds, okay, there's no duty to reconcile, you're going to effectively be able to use money and avoid the tax liability associated with a gain. Okay, this is a legal way to do it. You got to be careful though and understand where you have the liability. So don't be so enamored by all these fancy names of trust structures and trusts and unincorporated associations or whatever they want to call them, PMAs and all that. I like using the LLC. The LLC is where you get the protection from. It's not the owner of the LLC. Okay, so if you're owner of the LLC as a trust, so what? It just makes it more difficult to open up bank accounts. Okay, your most effective ownership structure in an LLC is going to be two owners that are not married, two members that are not married. They can be real owners where they have an actual interest, which is undisclosed, okay, because your operating agreement is private, it's proprietary data, or it can just be a nominee member. Then the way that's established is very nice, okay? So what we do is we amend the articles, or we set up the articles so that there's more than one owner from the beginning. So there's a managing member and a member, or two managing members, however you want to do it, okay? All right, so that's enough for that discussion. I hope that guides you in the right direction. It gives you the right consideration when you're looking at an effective way to manage financial risk, whatever that might be. Thanks for watching.